I would interview more people. The only issue specifically I don't have an issue with interviewing people. It's more or less people are sometimes camera shy and don't exactly know what to say. You know, so it's not really that. It's just more like respecting people's wishes. Some want to be anonymous, at least in words.
Maybe the hot
Maybe. All right. Do you have any thoughts, Jenna, about the NDAA?
Fuck NDAA.
Short and sweet. There you go. I mean, it doesn't matter who I go up to and speak to, they're all going to give you the same answer, you know? NDAA sucks, it should be repealed. In Jenna's case, FNDAA. You know, doesn't matter.
I'm telling you.
We don't belong here. Get us out of here.
Do you have any report backs from what's going on inside?
A lot of bullshit.
That's it?
A lot of bullshit, but you know, they said a lot of nothing.
Can you tell me exactly how many people are inside?
Well, the courtroom was packed. I was on the outside. I was right up there ready to get in, but it's just ready to end now. And the lead attorneys are coming down for the press conference.
All right, so it looks like it's wrapping up?
It's wrapping up.
It's wrapping up, okay. So we should have like a word from what's going on inside, an official word from what's going on inside, not too long from now.
National strike! Everybody stop working!
By the way, for those of you who are watching, you can follow me on Twitter at the Pella Report, THEPELLA Reports. That's where I usually make my updates and announcements. So hopefully if you're enjoying this stream, you can come back and watch me next time, because I appreciate viewers. And there is Kitty. Kitty has returned.
It's cold outside.
So he's gone now, but Jack says he loves you though.
I love him too, and I'm cold and frozen. My hands hurt. My hands hurt.
What is my next move after this action? Eating something that probably doesn't have meat on it. It's Wednesday. So if Matt is in there, I will get word from Matt. Matt is the mega streaming blogger, and
More right? There.
Yeah, a lot of us are the same.
can't say for sure at this point. As you can see, people are now starting to trickle out of the court right now. Sorry. I have to move around a lot because there are other media folks here and don't want to interfere with their pictures. I know the feeling.
Cool.
You can see people are filing out of court right now.
They're not reporting. They keep going dumb. And they're keeping us against each other. The one thing is we're all for America. We love America. But we're losing it because we have 20 of the 99% still asleep.
Amen.
Anything happen?
Stuff happened, but I didn't get inside.
So apparently the courtroom was so packed that not everybody was able to get inside the court.
The overflow room had overflowed, and people were waiting out in the hallways. Yeah, she's the thing. Oh, yeah.
So you can see people filing out. So the courtroom, the overflow room was overflowing as well. So there were a lot of people in there. It's not that people are asleep. People are scared and they don't know it. That's the problem. Cognitive dissonance.
Yes, we're still on the feed.
We're still on the feed. We're still on the feed. Yeah.
Or standing around and whatnot.
One of your guys. I'm glad we ran into you.
Anything to report on?
Let the Supreme Court handle it.
So let it go.
It's going to come down.
I didn't even get inside. I waited in line for 45 minutes.
So that's an unofficial report. Let the Supreme Court handle it. That's what it's going to come down to.
Huh? It's going to be an old familiar friend.
Okay, maybe I'll get word from. Hi again.
Hey, what's up, Mike?
Anything to report?
No, man. They are done. Everybody made their complaints, and the judges heard everything, and then they have to deliberate. What does that mean? They're going to reconvene today or deliberate for 6 weeks? I don't know. What it means?
That there was going to be a decision today.
All right, you got another account there.
I can't imagine.
Oh no, it's
Strange.
yeah, absolutely. I'm just wondering if we're going to get some more. People.
Oh, he is a nice artist.
I wonder if we're going to.
Yeah. Yeah.
As I mentioned before, I think my generation, 1980s, 1990s, I think they're more scared than they are asleep. We live in an age of information. I said this before today, I'll say it again. We live in an age of information. Ignorance is a choice. People know what's going on, they just don't want to do anything about it. The people in my generation much rather, hide in the bars or hide in the clubs in the weekends during their time off, or, waste all their time watching sports games instead of going outside, meeting other people, and doing things that matter. And that's the problem with my generation. Do I sound like I'm being righteously indignant? Yeah, I might be. If I can find him, I will. I would like to hear specifically from Matt. I think Matt's in there. I know he might have some words on, excuse me, he might have some words on this.
No, I tried like several different charges.
People pressed air because it's going to take an hour.
I don't have
So the crowd, as you can see, is getting a lot larger. I think it's going to spill across the street in a little bit because this crowd might be getting a little too large for this particular sidewalk. All right, we have some literature here, or some legal papers. Oh.
Come on. So, Ma?
So this pretty much explains the lawsuit against the NDAA. There you go. All right.
Yeah, well.
Yeah, I'm live streaming right now, yeah.
Oh yeah, they. No. Oh, I've seen that a lot of times.
Yes, Dave the Saxman is here. Yes, he is. He is present. Sorry.
Sorry.
Mm-hmm.
I didn't see you.
It's all good. As you can see, more and more people are crowding the situation. People are exiting.
Howdy.
Hello. Do you have any thoughts to share, Zach?
Not off the top of my head. No, I'm sorry.
As you can see, everybody is, in terms of being against the NDAA, it just speaks for itself. You're either against the NDAA or you aren't.
Well, okay, I will say that having read the provision in the NDAA of 2012 that this is all about, that, like, admittedly I'm not a lawyer, so I can't say I can't claim to have like a full understanding of the legalese, right? But you know, it's not that explicit in the sense that it would need to be interpreted by a judge to actually mean indefinite detention of U.S. citizens. But the caveat I'll add to all that is that, you know, frankly, we're talking about the state here. The state doesn't need a law to indefinitely detain you. They'll do it if they need to, or if they feel they need to, blah, blah. So in that sense, I still totally support all this.
Thank you. Hopefully I can find Matt. You said that he was just getting out. And it looks like... Oh, I thought something serious of sorts was going on up there, but it's not. It's not too serious.
That's how I try to argue with my pops over. There's no left and right. There's no Republican, Democratic. It's all the same.
Yoni might give me a good report back. I just seen Yoni exiting the court.
I should. I am trying to get into the habit of it.
Yoni, you have anything to share? I just saw you coming out.
So it was actually quite difficult for me to hear. We were in the overflow room, and so we basically had a microphone there. So I heard a lot of the arguments, but I'm still not quite clear what the conclusions are. So I'll hear later on from the press conferences about that.
Thank you. Was Matt in there? Matt?
I didn't see him.
Excuse me.
Put me something on that.
So, excuse me.
I know it's down. Yeah, I'm down with that.
You don't have to kneel down. You don't have to kneel down.
So as you can see, Occupy Justice is here with their signs: the right to a fair trial, the right to, I think that says respect, the right to refuse injustice, the right to protect your innocence, the right to refuse injustice, the right to due process, the right to assemble, the right to protest, the right to stop indefinite detention, the right to public space, the right to live without harm, the right to justice, the right to end oppression, and the right to, I guess, reclaim democracy. I'm sorry, I don't mean to get in your way.
Okay. I like the idea we had before, but what we came up with, the idea was that we're at the funeral, and then everybody's
I don't know what one of the police. I can't speculate what a police officer would think if one of their family members were abducted. As you can see across the street, they're staging for a press conference, and I'll be going over there shortly. Where the press conference is taking place. In fact, I'll be on my way over there right now, so nobody else can crowd me, so I can get a good vantage point.
The status quo doesn't allow for change anymore, and that's got to a point.
Why, by the way, while I have 125 of you on right now, you can follow me on Twitter at the Pella Report, THEPELLA Report, and I invite you to follow me if you can. That's where I usually make my updates and announcements. Can I sit down? Can I sit under you?
Yeah. And if the police give you any problem about it, just tell them that I said it was okay.
Okay.
Or off to either side.
We didn't hear it very well.
So there's my respective counterpart from We Are Change, Connecticut over there, Jeff. Well, I can't. I don't think any politicians were in the court. No. At least wasn't advertised that there was, and if there was, I'm sure there'd be a lot more. There'd be a lot heavier of a police presence than there is right now if there were any high-profile politicians in the court.
Hey, Sven, it's Atif. Hey, I just saw your reply to my email. You asked for the information or where it is. If that's all in the email. Okay. It's tonight. Can you? We open the doors for press at 3:30. Can't we get it on?
Wait.
Okay.
Knock down a mic.
Yeah. All right. Thanks.
High-profile politicians. Okay, so Ellsberg and Hedges are in there, but I don't really technically think they're politicians per se. They're more like, social commentators and lawyers. Naomi Wolf is here too. The most mainstream media outlet that I see that's here is RT. We Are Changes here. Hispanic TV's here. Undercurrents here. WBAI is here. There's Chris Hedges.
The media to kind of make a clean half moon shape here, and supporters on either side. And anybody with signage that wants to stand behind, please stand behind here with the signage. Thank you so much.
So it's all good.
Well, I think we're all going to stand here because this is the semi-state. Oh, you moderating this first time? I ordered
Well, good morning, everybody. Thank you so much for being here. Can you hear me? So today is a historic day, obviously. We have hundreds of people here. I'm not sure how many, but... Your name? Sorry, I'm Secretary Bowman, one of the plaintiffs in the lawsuit. Also initiated the multi-plaintiff stage, and my team coordinates it. We have a team around the world that works on this to make this happen. So first of all, thank you to everyone around the world who is making this happen today, because it's a collaborative effort. Secondly... Can you speak louder? Yes. Secondly... No. Okay.
You gotta shout.
You gotta shout? Sorry, guys. Okay, I will shout.
Hey!
No? What do you want me to do? Just speak just loud. Okay. Well, thank you again, everybody, for being here today. Obviously, this is a historic landmark case. The judges that just spoke started to hone in on exactly what we're going for, which is the disingenuousness of the DOJ in this case. We really want to expose that fact. But first of all, I'll speak in just a moment, but I'd like to open this up with our two lawyers, Bruce Afrin and Carl Mayer, and then we've got a lineup for you of the plaintiffs and other people who have supported us from day one. So starting out with Bruce Afrin.
Good morning. You're free to ask any questions. Let me make a statement first, I suppose. Can you all hear me? Come on, close to the mic. All right, I will speak. Give me a moment then. Okay, that's the best way to get in the hat. I will speak as loud as I can. If any of you are filming this and I sound like I'm screaming, use your data capacities to make me sound more normal. We argued today the case challenging the NDAA in the Court of Appeals. This is one of the elite courts in the United States, and the judges, I think, were really up to the court's reputation. They were very sharp in their questions on both sides. They really challenged the government to prove that this is, in fact, not a new law, but an old law that merely has been recodified. The government's position is that the NDAA is merely an old 10-year-old copy of the old AUMF, which is the authority Congress gave the government to go to war in Afghanistan. We've dissected this in our briefs, and Judge Forrest in the trial court clearly agreed that this law broadens any pre-existing power of the military to detain people in this country. In fact, since the 1860s, the Supreme Court has held that no American may be detained in the United States by the military. There is a constitutional barrier between the military and the civilian, whether they are a citizen or not. The NDAA breaches that barrier. It allows, for the first time by law, the military to incarcerate citizens in this country. The government was challenged by the court to say that, to prove that this is an old law and is nothing new. The government could not do that. The AUMF plainly broadens any power of the government that previously existed. It is an attempt by the executive branch to take on vast detention authority, not akin to a democracy, but like most of the dictatorships we've had the misfortune to know over the last century. If this power is upheld and used, it means that Americans can be subject to military imprisonment if the government deems they go too far in supporting an unpopular cause tied to the Middle East or to terrorists. If someone raises money for Guantanamo inmates and sends that money to their lawyers to support their defenses, that could be substantial support of Al-Qaeda. If someone hosts a webcast that figures from terrorist groups or Al-Qaeda are invited, is that substantial support? This broad statute endangers basic speech. We've seen professors incarcerated in this country because of such actions. We've seen at least one journalist taken by the U.S. in Yemen, Mr. Al-Hajj, who was later released after a long period of detention on this theory. Our client Chris Hedges was detained by the U.S. military long before this law was ever passed because he left the press pool. Surely if this law now exists, such endangerment is going to be more common. The government says that independent journalism is not subject to this law. Well, we don't know what that means. It's not in the law, that exception. And administrations change their view. In fact, Judge Kaplan bluntly said to the government, don't administrations frequently change their policies? In fact, one notable example actually relates to medical marijuana, where the Obama administration early on said it would not prosecute such cases, but close to the election changed its policy and began prosecuting medical marijuana providers in California. Well, that's not an issue here. It demonstrates that a statement by the government today is not a guarantee of rights. Rights are guaranteed by the Constitution. Rights are endangered when statutes usurp the Constitution. This case is about guaranteeing that we do not become a society dominated by the military. My colleague Carl Mayer will mention and discuss a letter from many generals addressing this statute. This case is about keeping that barrier absolutely clear between the military and the civilian jurisdiction. The framers of the Constitution were very clear to make certain of two things. One, that the military is always commanded by civilians. And two, that the military will never have authority over civilians. This law changes that long-standing rule, and it is a threat to the basic liberty of people in this country. Do we think that concentration camps will arise from this? Of course not. But this is an erosion of basic principles of law, and it's our job as lawyers to stop that erosion before it grows further. There's an old saying, a fish rots from the head down. When you threaten the Constitution in its basic goals of liberty, the rest of that body politic will begin to decay. Today we felt that the court was very thorough, was very active. They questioned us equally, which is their job. We don't know how they will rule. We think they should rule in our favor. We think the balance of the argument lies with us. But it is not our job to predict. It's our job to make our arguments. My colleagues will also say this. I want to thank the people who've been involved in this case. Bob Jaffe, who's worked with us. David Reeves has worked with us, both dedicated attorneys. Tangerine Boland, Lexa O'Brien, and many others. We have paralegals who've been actively involved. Dan Ellsberg and Noam Chomsky and Chris Hedges and Lexa O'Brien and Tangerine Boland and Brigitte Jonstatir lent their names to this case. Something many people would be afraid to do. I want to say one more thing. Carl Mayer and I launched the domestic surveillance class action 6 years ago. At that time, dozens of lawyers around the country joined with us. When we launched this case just a few months ago, throughout the great breadth of this land, only 2 other lawyers called us to join us. That was Bob Jaffe and David Reeves. That demonstrates the chilling effect that a statute like this has. 6 years ago, before such a law, dozens of lawyers called and joined. Today, only 2. That demonstrates the fear people begin to take on in a democracy. Thank you very much. I'll call on Paul now. Well, if you have any, let me have Paul speak, and then maybe you can throw questions to both of us. Then Chris Hedges will address you.
Thanks, Tangerine. By my count, today is day 4,163 of U.S. involvement in war, with no end in sight. This seems to be a perpetual war against an undefined enemy, terror. Even though this terror has existed for a long time, we have put all the military might of the country at the disposal of ongoing war. Today's challenge in court to the latest attempt to pass laws that would subject Americans to the detention of the military is just one of many statutes that both the Bush and the Obama administration have passed and then worked to target domestic people within the United States of America. That includes citizens, residents, etc. You have in the United States now warrantless wiretapping. You have, for the first time last year, the FAA authorized 106 drones flying over our skies. And now this law seeks to make it lawful for the military to detain not just U.S. citizens, but any civilians within our borders, which has been a principle, an article of faith in the United States law since at least Ex parte Milligan, which is a Supreme Court case following the Civil War. So this is part of an effort to change the climate. We hope we will prevail in this litigation. The plaintiffs, thankfully, and I can't say how honored I am to represent Daniel Ellsberg, Chris Hedges, Tangerine Boland, Kai Wargala, Alexa O'Brien, all of them together have worked to make this a very important, I think, challenge to the ever-encroaching national security state. And together, the plaintiffs and the lawyers have determined that whatever the outcome today in court, we will pursue this. If we don't prevail, if we do prevail, we will continue to ask the Obama administration, which said that they would veto this provision, to honor that pledge and to make sure that forever there will not be detention by the military of American citizens. So that is what we intend to do in the future. We can't read how the court will decide today, but we will pledge to fight on into the future. I'd be happy to take questions. There are many people, I think, who want to talk to some of the plaintiffs. I'll let Tangerine orchestrate it, and I think we'll probably do questions after.
Yeah, well,
Let me just note, Paul corrected me. I omitted Kaiwagala when I noted our plaintiff. She's a young German student, a master's degree student who came in to this country to testify specially despite serious
Oh, and I neglected to, I omitted Birgitta Janstad here, and Noam Chomsky. I got it. You got it. All right, now we have everyone.
We covered everyone.
We covered the base.
So should we take questions?
Yeah, let's take that again.
We represent Tangerine Boland right here, a group called U.S. Day of Rage, an interest group, Kai Wargola, Birgitta Janstad, a member of Parliament of Iceland, Noam Chomsky, Chris Hedges, and Dan Ellsberg. Anyone else?
Alexa O'Brien. We got that. But also, we're very honored as well to have the participation of Cornel West and Naomi Wolf and other leading fighters for freedom in the United States in this effort. And I can't thank them enough for their writing and their inspiration. And in that case, it makes it a treasure to pursue a legal fight that sometimes can get tedious when you're fighting the government of the United States.
Let's take a few questions for our attorneys and then we'll continue with our lineup.
We're here if you have questions.
So it was so crowded in the courtroom, many of us couldn't get insight as to what's
Please repeat the question. The question was, can we give insights as to what the proceedings were like, because many people couldn't get inside the courtroom?
Well, it's very hard to read the panel. I recall during the first decision where we prevailed and obtained an injunction from Judge Forrest, the plaintiffs took us aside afterwards and told us quite appropriately that they thought we could have made thus and such argument, because they are very forceful plaintiffs, and they should admonish their lawyers for not doing thus and such. And they thought we wouldn't prevail, and we did. In my experience, it's almost impossible to read a panel. There was tough questioning on both sides. I think regardless of how this turns out, the panel sees that we have won, because we have brushed back the effort by the national security state to extend its reach into our domestic politics and laws. And I think that's the case because the only hang-up that the judges seemed to have was they thought that the statute already exempted citizens and residents from detention within the United States. If we do nothing else but make it clear that that is the case, we will have won. Although we will, regardless of the opinion, if we do not prevail on everything, take it all the way up to the Supreme Court until we do prevail or have exhausted all of our remedies.
I think that encapsulates it. The court was really concerned only about one section of the law, which said, well, existing law as to citizens or people in the U.S. is not offensive. And that's the only concern the court seemed to have. Otherwise, they didn't seem to accept any part of the government's case at all. And we answered very bluntly, well, that exception says for people detained in the U.S., existing law is not effective. And we answered the court and said, but it presumes they'll first be detained by the military, and that's what the Supreme Court has said is unconstitutional. Yes?
If the challenge to this provision is successful, what's the effect it has on the entire NDA?
The NDA the question was, if this challenge is successful, what is the effect on the whole NDAA? The NDA is a vast appropriations bill. This is one small provision. This case only affects the question of detention of people by the military for substantially supporting these groups. The appropriations bill is not affected, and the part of the NDAA dealing with combatants remains untouched. And we don't challenge that. If you're a combatant, you're a combatant. You live with the law.
Do we have a time frame idea when the judges might answer that? The question was, do we have a time frame for a decision? The answer is we don't. They agreed at our instance to hear it on an expedited basis. Typically these things take months rather than weeks, unless the panel has some sort of foregone conclusion in mind.
I will note the court suggested in the argument we might want to wait until the Supreme Court rules on a case called Clapper, also featuring our good friend Chris Hedges as the plaintiff, which involves a question of whether journalists have standing to challenge the FISA wiretap law. So the court might actually wait until the Supreme Court rules on that decision, and that might not come down until June, so we may have quite a bit of time to wait. Behind you, there was a question. And we're gonna...
Yes, you have mentioned that the freelance journalists, they won't fit into, they will fall into the law, into the NDAA. But my question is, and then one of you also mentioned that if you are on the borders, they will be able to apply the law to you. So how about Julian Assange, who is right now in London? How about that law would apply to him if he's moving into the other country?
The question was, are independent journalists encompassed, encapsulated, or captured under the law, number one, and number two, how would the law relate to Julian Assange?
You know, the answer is Julian Assange is being investigated for a violation of the Espionage Act because he took documents that were classified from a member of the military, Bradley Manning. He really doesn't fall directly under this law, but it's broad enough. It is broad enough that certainly the government probably could use this law to incarcerate Julian Assange.
Does that also include somebody like the Icelandic member of parliament, Birgitta Jónsdóttir, who's supposed to come here in April and is fearful for her safety?
Tangerine Bowler wishes to address that, but the answer to that is yes, it can apply to any such person.
So
You got to say
my lawyers can correct me on this, but we have discussed it at great length. There are two hypotheses on the rationale and MO behind what the government is doing here.
You got to scream.
There are two hypotheses regarding what the rationale and the MO of the government, what the rationale is doing. What their rationale is here. The first one is that there's been a pattern of disingenuousness on the part of the Department of Justice. From day one in this case, as far as it appears that there's been a deliberate conflation of the powers of indefinite detention under the Authorization for Use of Military Force from 2001, which allowed George Bush and company to go after terrorists. It had a very narrow three classes of people that the AUMF applies to. It's people who participated or planned the 9/11 attacks, members of Al-Qaeda or the Taliban. That's it. Very, very narrow. Those are very firm parameters. However, the 2012 NDAA, the provision over which we're suing, added a paragraph, 1021B2. The government keeps claiming over and over again that the AUMF and NDAA are exactly the same, but 1021B2 does two things. It possibly retroactively legalizes the fact that they have been over broadly interpreting the AUMF for who knows how long, perhaps since 2001. It's a huge quagmire. Our case is potentially the latch on Pandora's box here. We threaten to expose the fact that possibly two administrations have been over broadly, possibly illegally interpreting a law, the AUMF. It's really dangerous for them. So 1021B2 appears to me, at least in my investigation, to be a deliberate attempt to legalize previous activities and to, they keep saying affirm and codify the AUMF. You don't need to codify a law, it's a law. The second theory on this, though, is that 1021B2 is very carefully crafted to go after people like Julian Assange and WikiLeaks. We don't know what's happening with the secret grand jury investigation. Obviously, none of us are privy to that information. But they haven't come forth with anything so far. The language of 1021B2 is so carefully written that perhaps it's written to apply to people like Julian without sending alarm bells ringing throughout mainstream media. It's a fine-honed tool, and you can see that in the court arguments. The arguments over and over again, they're very careful with their words. If you're independent enough, you won't be in trouble, but they won't define independent. They won't define associated forces. So throughout our case, there's this deliberate conflation of these two laws. They would like you to believe that they've always had these powers of 1021B2. Patently false. So I hope that answers your questions on Julian Assange. Just the last point on that. If we allow this door to open, this is a slippery slope. Whatever the government thinks, they may think, we're the good guys, we're only going after the bad guys, we'll never use these powers incorrectly. Well, I'm sorry, that's BS. And if they want to use these powers on Julian Assange and anyone else related to WikiLeaks, like Jacob Applebaum, who's here today, who will speak, Birgitta Jonsdottir, etc., then that is a slippery slope that can be used to detain any of us, and that's obviously what we're trying to stop.
Adrian.
Yeah.
So, how many more questions can we take? Because there are people who need to speak.
Let's move on.
All right, we have
yeah.
Dan. Yeah.
Dan,
Dan Ellsberg is here.
Dan Ellsberg. Well, I spent the other night reading a 112-page decision by Catherine B. Forrest. And at the end of it, I had a feeling that I don't have every day of the week these days. I felt proud of being an American. That came to me overwhelmingly as I read her arguments. Here's a judge appointed by President Obama who is shamefully being confronted now with arguments in favor of a blatantly unconstitutional provision. And for once, a judge is willing to say this is facially unconstitutional no matter to whom, to when, under what circumstances. I doubt if the circuit court judges, I'll be very pleasantly surprised if they have the courage to do what she's done and not simply be time servers for their own advancement. I doubt if this rule will advance her very much. Something that affects me very strongly is this. Someone who is able to see so clearly that 1021b2 of the National Defense Authorization Act, which allows you to put an American citizen in civilian in military custody, treated like Bradley Manning is in the Marine barracks right now, indefinitely without charges. That's not a fight we had to make in 1776. George III didn't have that power. No King of England had had a power like that since John I. So here we have a president, a Democratic president, who is wiping out the Magna Carta as well as the Constitution. What seems to me very clear is the three senators who were advising, who were arguing this for the indefinite detention without charges of American citizens against the Fifth Amendment is well described as an enemy of the Constitution of the United States. And I'm afraid that is true of the president at this point in going along with this, having encouraged it earlier. And if every senator who votes for that, and let me remind you, every one of them is a civilian, took the same oath that Bradley Manning took and that I took as a Marine. And that is not for a commander-in-chief. It is not, who's not mentioned. It is not to obey the regulations of the commander-in-chief. It is solely to support and defend the Constitution of the United States against all enemies, foreign and domestic. It was clear to me for years that we were governed by a handful of people, Bush, Cheney in particular, Addington, Rumsfeld, who were, in a technical sense, and I do not mean rhetorically, enemies of the United States Constitution. That does not mean I thought they were traitors, that they adhered to anybody else, or that they didn't feel loyal to the United States and patriotic. I'm sure they wanted the best. And they're absolutely entitled to say that they believe that the current rights in the Bill of Rights are inappropriate, especially in a world of terror, and that we no longer deserve or can afford freedom of speech or freedom of expression. That's their right as Americans. It is not their right to say it or act on it as members of the Congress of the United States or people who have taken that oath to support the Constitution as it is. And the fact is that the people representing that case now, that the Judge Forrest, excellent decision, firm decision of a patriot who understands the spirit of this country. It absolutely is right. It deserves to be confirmed. Those who vote against it, I would say, are voting, in some cases, you'll have to say, deluded, very deluded. But where they understand that what they're doing, they are violating their oath. So what it comes down to is, we can't trust the leaders of this country to protect our rights any more than we can trust Goldman Sachs or Wall Street in general when they sell us security. Well, think of the other institutions I could go through at this point. It really is up to us. If Bradley Manning gets what he says,
namely discussion, information, debate, and reform, then he says we are not doomed as a species. That sounds grandiose, that sounds self-serving there. It is not. In the world of climate control, in the world of nuclear weapons, but in the world of civil liberties, where this administration, this term, is turning in once again to the fourth term of George W. Bush on that area, it basically is up to us, no one else. And thank God we have an ally like Judge Elizabeth Forrest, but we need to support her, point out that she is not just expressing an opinion, she's saying blatant truth. And it's up to her to congratulate her, back it up, and see that the Supreme Court sees the light. Thank you.
Thank you. We've undergone a corporate coup d'etat.
Your name?
My name is Chris Hedges. Case Hedges versus Obama.
Can you spell that?
He is the captain.
We've undergone a corporate coup d'etat. There is no impediment left now to corporate power, and the corporate state understands that as the economy continues to deteriorate, as the effects of climate change, and we just bore the brunt of that with Hurricane Sandy, over $70 billion worth of damage kicks in, there will be inevitable blowback on a betrayed population. And what's happening in this court now is the last thin line of defense between protecting what is left of our anemic democracy and the imposition of a military state. The deterioration of civil liberties under the Obama administration has complete continuity with the attack on civil liberties under the Bush administration. In fact, under the Obama administration, it has been worse. The radical interpretation of the 2001 Authorization to Use Military Force Act as giving the U.S. government, in particular the executive branch, the right to assassinate American citizens. And we just saw the white paper leaked to NBC on the drone attacks. The use of the Espionage Act, as Dan mentioned, to shut down all whistleblowers, any narrative that challenged the official government narrative. The FISA Amendment Act, which retroactively makes legal what under our Constitution has traditionally been illegal, the warrantless wiretapping, monitoring, and eavesdropping of tens of millions of American citizens. And we know that our personal information is being stored in supercomputers in Utah. And now the National Defense Authorization Act, Section 1021, overturning 200 years of domestic law to allow the military onto our streets to seize American citizens, strip them of due process, put them in military facilities, including our offshore penal colonies, and hold them indefinitely. The corporate state knows what it's doing. If the Congress had put in one small sentence saying that U.S. citizens were exempt from this legislation, we would all pack up and go home. But they will not, because as Senator Graham pointed out, it is designed to detain U.S. citizens. And the bottom line is, as this unrest continues, the corporate state does not trust the police to protect them. It wants the ability to call in the military. This case is one of the most important cases in decades in the protection of our most basic and important constitutional rights. And the heroes of this case are standing next to me, who have not earned a dime from this: Carl Mayer and Bruce Offron. Walk-on parts. They're the ones who do the work. Thank you very much.
Thank you. Thank you.
Hi, I'm Alexa O'Brien. How is everybody? Thank you for coming today.
All right.
I just prepared a short statement. When the U.S. government said in federal court that they wouldn't guarantee I wouldn't be indefinitely detained under Section 1021B2 for articles I had written on the war on terror, what was that